Okay. So, welcome everybody to a workshop working with Benjamin on law. My name is Alexis Alvarez-Nakagawa, and I'm one of the hosts of the workshop together with Hannah Franzki and Rafael Vieira. We are going to have a 3-day workshop session to explore what Benjamin has to offer to scholars interested in examining contemporary uses of law. We aim to get a better understanding of both the contributions and limitations of Benjamin's writings. And in a way, the title of the workshop suggests that it is possible to work with Benjamin to understand the law, a claim that will be up for discussion throughout the workshop. The idea of this activity born at the end of 2019. We did not expect a global pandemic would come soon after. As you can imagine, we originally envisioned something very different for this workshop. We believe nonetheless that the hybrid format we adopted at the end, with some participants in Berlin and some more participants interacting virtually, keeps the original ethos of the workshop by mixing up the international and the local, the virtual and the presential, public and private sessions to gather people from different corners of the earth to discuss Benjamin's ideas on law. The workshop is funded by the Walter Benjamin Award for Young Researchers. We'd like to thank our sponsors, the International Walter Benjamin Society, the Walter Benjamin Archive, the Leibniz-Zentrum for Literature, for considering our project and for their generous support. We are particularly grateful to Ursula Marx and Daniel Weidner, who guided us at the beginning of this process, and to the Leibniz-Zentrum team, especially to Eva Axer, Judith Lippel, Georgia Lumer, Dirk Naguchewski, who helped us in the last stages to organize a presential workshop in Berlin and to edit the recorded lecture. We'd also like to thank the workshop participants for their flexibility, resilience, and engagement with this project over all these months. Special thanks also goes to our keynote speakers, Andrew Benjamin and Julian Shi, who showed not only their knowledge of Benjamin's work, but also their good and amazing, I would say, technical skills to record their lectures. We are also indebted to Gisela Catanzaro and Sami Khatib for chairing the roundtable session that we will have on Saturday as the final session. Let me say that 2021 marked the centenary of Benjamin's Critique of Violence, which is, as you know, one of the main sources of Benjamin's ideas about law and justice. This is indeed a happy coincidence. Let's celebrate then the anniversary of Benjamin's work by making it speak to our contemporary predicament. Before starting with the Q&A, let me introduce today's speakers. Andrew Benjamin is Distinguished Professor at the University of Technology, Sydney, and Emeritus Professor of Philosophy at Monash University Melbourne. He is an internationally recognized philosopher and authority on contemporary French and German critical theory. In 2013, he published Working with Walter Benjamin, Recovering a Political Philosophy. This book, which has worked as an inspiration for the title of this workshop, develops the idea of working with Benjamin, seeking both to read his corpus and to put it to work to show how a reading of Benjamin can open up issues that might not themselves be immediately at stake in his text. Julian Shi is lecturer in critical theory and founding co-director of the Center for Philosophy and Critical Thought at Goldsmiths, University of London. She co-chairs the Walter Benjamin Research Network and serves on the editorial board of the series Walter Benjamin Studies for Bloomsbury Philosophy. Julia is also the translator and editor with Peter Fembes of a new annotated critical edition of Benjamin's Toward the Critique of Violence, which was recently published by Stanford UP. Please have in mind that the Q&A is being recorded. You are welcome to post your questions in the chat, or alternatively, you can ask them orally. In either case, please be brief to allow other people's participation and keep your microphones off when you are not speaking. So, without further ado, the floor is now open for questions. Do we have any question? Okay. Let me break the ice and give you some time to maybe type your questions in the chat, and let me ask a question myself. So this is a question for both Andrew and Julia. Hi, Julia. My question relates maybe to an aspect that is fundamental for this workshop, which is what it means to work with Benjamin on law. What are the potentialities and limitations in using Benjamin's writings to understanding law in our contemporary world? Or maybe, you know, in your work, what were the main methodological difficulties you found in using Benjamin to understand our world or to understand particular issues like law? In your lecture, Andrew, for example, you mentioned that very briefly that the difficulties entailed in Benjamin's text and the amount of interpretations available, for example, in relation to the critique of violence as a challenge, you know. So, you know, have you found any other difficulties when working with Benjamin? You, Julia, have you found difficulties when preparing this new translation and critical edition of Benjamin's work?
Can I start? Should I just start? So, well, first of all, I want to thank you and the other organizers for, you know, inviting me to address this conference on a topic that's obviously very sort of present in my mind, having just finished this edition. And in fact, your question really inspired the genesis of the edition, actually. And a lot of what, I mean, I don't know how many of you are familiar yet with the volume, but also like sort of really informed the way we decided to structure and also include various entry points for people reading Benjamin, either for the first time, that's unlikely obviously, but for the first time in the sense of maybe not knowing German, to those who have been working with Benjamin for a very long time. Part of what sort of informed our sort of editorial decisions and also part of the translation choices that I made and also Peter made in respect to not just the essay, but also the 22 fragments that are associated with it, is that not only did we want to make the text actually accurately accessible to non-speakers of German. I think everybody knows that some of the previous translations were sort of riddled with errors and misinterpretations of key points and sort of misconstruals of what was going on textually as well, but also provide a new way of working precisely with Benjamin. By which I mean, you know, working with Benjamin has to now, I think, extend beyond paraphrasing Benjamin. I think, you know, Benjamin's such a difficult writer and writes in such a gnomic way that he tends to be cited as an authority for all sorts of purposes, which is great on the one hand, I guess. I mean, there's exposure, but on the other hand, like, you know, I wonder why people even read Benjamin if they're not going to actually like, think about like what's going on in the text. I mean, obviously, I'm like biased towards the philology, just having done this kind of work, and I'm very much like I feel very much at home in our archives. So I enjoy this kind of work also, and I find like intrinsic value in it. But beyond my own personal interest in the philology, I mean, what I find important is to understand that Benjamin wasn't writing in a vacuum, especially in a text like this, Toward the Critique of Violence, which has been sort of extracted and abstracted from its context so much in the past 100 years, in spite of the fact that it had no reception whatsoever when it was first published. And by the way, part of what Peter and I did in the volume is to sort of discuss how little reception it actually had, the essay, right? And the real context within which he produced the essay. It was sort of maybe for a project on politics, but then he actually gave that up as well. It turned into another project altogether. And then there's this document that actually Ursula Marx like very kindly helped me sort of gain access to many years ago when I was writing my dissertation, and we published it in here that indicates that up until 1927, he was still thinking about the critique of violence in other, you know, in a completely different context. You know, part of it, what, you know, we wanted to show that what working with Benjamin means is also understanding the context and also maybe the limit, you know, not just the limitations, but also the true sort of provenance and power of what Benjamin actually says, given the context of what he says. So, my presentation for your conference draws on a lot of this background work that we did as well, right? So we historicized quite a bit of the vocabulary so that he's not just simply coming up with this idea of legal violence out of the blue, as it were, right? He actually thought about, there's a context with the way in which Staatsgewalt, Rechtsgewalt, so on and so forth, right, means something in the German language. And specifically, it's Prussian language, actually. We sort of very quickly discovered that in the legal context, the life of law lives its life outside, sort of rather and insidiously independently of political life. So a lot of the police law actually that still governs Germany, and especially in 1921, actually, when Benjamin is writing, is simply still the one that sort of Robert von Moll came up with when he first articulated police law, for instance, in the German context. So nothing changed in the process of the 19th century, even though politically a lot changes in the 19th century for Germany. Even in 1921, which is obviously a couple of years and after the end of the First World War, just 2 years after the revolution that Benjamin also kind of refers to, but not really, not directly, the legal terminology indicates a different kind of life. It's a life of legal terminology that has its own power. And I think that's part of what Benjamin is actually really interested in, is sort of disentangling political power from legal power in such a way that it becomes evident how to sort of dissociate the myth of this, as Andrew was talking about in his talk, the naturalization of certain forms of power as sort of inextricably tied together, right? Part of the mythic form that sort of legal power expresses itself is that it becomes it becomes seen as intrinsic to the normal and well-functioning of a constitutional democracy, which is the political state at which 1921 was at in Germany, but still sort of drawing on the legal terminology from 1871, 1830 something, So I think that's one of the things, talking about working with Benjamin has to, take seriously the anachronisms that are embedded within the text itself on the level of terminology, especially when you're talking about law. Because law is nothing but also the performative, right? The performative power and the performative violence of its terminology. So that's one thing I wanted to say. Working with Benjamin is very interesting in this respect because it also does make us rethink about today's structures of especially police violence and the production of vulnerable bodies, and other topics I didn't get to cover in my keynote, but I addressed in the volume itself about his thinking about self-defense in the context of decoloniality. Those things are important today, and those things were important to him then, and those things are built on a illegibilization, if you will, right? Qua maybe naturalization of certain forms of legal power as non-anachronistic. So just to disentangle the anachrony of these terms is really part of what I think working with Benjamin today means.
Also, I'd like to thank everyone for inviting me to participate in this event. Obviously, for me, everything that Julia says, I endorse completely: the necessity for philological rigor, the need for contextualization, historicization, etc., etc. All of that is important and fundamental to how we understand the text and its location and future. That said, the notion of working with, I'm afraid for me, this is more a disciplinary position than anything else, I suppose. Not that any one discipline is more important than another, but there are disciplinary positions. And I suppose that from within philosophy, what I am interested in is, as it were, the translation of a lot of these reflections or thoughts or arguments into how we think about law today, and therefore what, in some sense, the afterlife of this text might be in thinking about law. Now, once you pose the question in that way, it does seem to me that and everyone can find their own way into this. There's no one right way. But one of the ways I think about this is the exchange between Rosenzweig and Buber over the relationship between law and life. And there's this great moment in the 1920s, in which the whole problem of how one understands this relation comes to the fore. The words for law are always going to be complicated, less complicated in English, much more interestingly complicated in German. But just in general, the question is then the relationship between law and life. Now, I tend to read, heretically or not, Benjamin as a philosopher of life. And I have the German edition as a PDF, and if you run a word search through it and come up with the number of times the word life appears, it's actually very interesting. And so I tend to think that my way into it is to read it as engaged with the question of life. And that therefore, part of what, when Adorno says, can we live, I'm not sure how to translate it, a correct life or a just life, im Falschen. What Adorno is interested in is this question of how one lives a life. And you can begin to find other instances in which the question of life emerges. And then we have, again, as a philosophical trope, the complex interplay of Giorgio Agamben and Hannah Arendt over the question of mere life, and then for Agamben, bare life. And for me, at least, what I'm interested in is a project in how one thinks about the relationship between law and life, and that therefore, for me, the value of this text, recognizing again the necessity for the scholarly work on the text that I don't do down for a second, that read in relation to the other text that we have, which is there in Schollem's Tagebücher, which in English is known as Notes to a Study on the Category of Justice. Once you begin to put these two texts together, whether justified or not, it's clear that there is a project that's Benjaminian in inflection. I'm not saying it's necessarily his, but it's Benjaminian in inflection in thinking about the interplay between law, justice, and life. And therefore, I suppose for me, working with him is his capacity, and I think it's enormous, to contribute to a specific philosophical project, which is the interplay of justice, law, and life. And clearly what this is gesturing towards is, a political theology that wants to get away from, the Schmittian heritage, understood as not the heritage that comes from the books on political theology, but comes from the very early work on the Catholic Church, the work influenced by Malebranche, in which what one becomes necessary is to move to one side the dominance of oikonomia, and therefore of belief and faith, and rethink the question of life in relation to law and what that means. So I think that Benjamin is fundamental to the development of that political theology. And again, my interest is, I'm just being idiosyncratic, my interest is with that. And therefore, the value of the text resides in its capacity to contribute to a specific philosophical project, which is either a justified project or not. So for me, the question of working with has to do with a relationship to a specific philosophical or philosophico-political project, the justification of which is external to a commentary on Benjamin.
Thank you, Andrew and Julia. I think that we have one question. Hannah, do you have a question? You are mute, Hannah.
Yeah. Oh, sorry, I double-clicked, so I switch it on and I switch it off again. Well, first of all, thank you all for joining us today. Thanks, Andrew. Thanks, Julia, for agreeing to pre-record the lectures. My question is for Julia. I was really excited to hear in the last. Can you hear me, or do you want me to? I can go closer to the mic.
It's just a little echoey, but I can hear you.
Okay. Okay, maybe that's better.
Yeah, that's better. Thank you.
Okay. So thanks again. So my question, I was really excited to see that in the last section of your talk, you got to speak about the relation of law and capital in Benjamin and the link between the critique and the fragment of capitalism as religion, which in my opinion is at least as enigmatic as the last sections of the critique of violence in terms of what to make of the movement Benjamin describes. And I wonder if you could expand a bit more in what, in your opinion, like how both texts speak to each other, and if you could develop a bit more on your idea about like the financialization in law, which I'm not sure I understood completely from your talk, and maybe you could just expand a bit more.
Yeah, thank you very much for the question. So I've actually been working on the capitalism as religion fragment in a very different context, although probably not, I mean, so I have like two sort of maybe competing narratives in my head about like how the two relate. But in terms of what I presented in the talk, there is a very enigmatic, as you say, sort of reference to law, specifically the pagan character of law in capitalism as religion. And he also refers to Sorel in Capitalism as Religion. Based on just those two facts, I mean, there's a clear sort of linkage between the way he's thinking about what he calls mythic violence and its operation along a sort of self-perpetuating dynamic in the Critique of Violence, and some of the ways in which he's trying to disentangle capital, thinking of capitalism from certain of its purported foundations in capitalism as religion. I think that how one sort of can see the way that law and capital are sort of bound together by virtue of what he thinks of as the fate of capital is precisely by sort of the sort of parallelisms that one can see in the way capital is said to be sort of driven by an dynamic of inculpation and expiation that at best hopes for a complete de-expiation, so like a complete removal of the entire inculpation expiation dynamic, even though according to sort of the idea of a fate, of the idea that capital has a fate into which capitalism draws all of natural life, that is merely like a bare minimum of a hope that doesn't actually do anything but perpetuate even more the idea of capitalistic fate. He describes mythic violence in very similar terms in the Critique of Violence. And specifically, I think that it's interesting that in his description of mythic violence in the Critique of Violence, he uses his example of a materialization that doesn't die, right, but sort of lives on in a very specific way. And this is, of course, like, you know, illustrated by the myth of Niobe. But what's interesting for me here is that basically it seems like what Benjamin is proposing is that the governance of bodies as sort of policeable subjects or policeable entities depends on a similar kind of like materialization of vulnerability that simply lives on, doesn't allow itself to even die, right? And that is very much parallel to the idea that in the Fragment Capitalism of Religion, he describes as a way for capital to maybe come up with this idea of instigating a world condition of despair, as he calls it, in the vague hope that despair will sort of draw God, the divine also into the fate of humankind, and therefore sort of break apart the dynamic that perpetuates itself, but in other, but nevertheless, like sort of, posits as the means for its salvation, the very means by which it perpetuates its own condition, and that is cast in terms of debt specifically. So what I think Benjamin is trying to sort of allows us to think, even if he doesn't like say it altogether explicitly in these terms, is that there is a kind of link between the policing of certain kinds of bodies, which is a production of bodies that are policeable, and a kind of financialization or like exploitation of them on the financial level. And I think that this allows us, if we're thinking about what to do with this idea today, especially, right? I think this allows us to think the policing of certain, as he says, like especially vulnerable areas, as not thinkable without its intersection with the law, the idea that the policeability of bodies is tied directly to financialization, especially of those areas themselves. So that's sort of what I have to say. I mean, it's, obviously Benjamin leaves it quite vague, but I think there's a lot of potential here to develop precisely, the idea not just of like a, positing vulnerability as outside of law, but vulnerability as being produced as an exploitable resource for law, by virtue of where law ranges in precisely what it deems to be vulnerable areas, and that is all in service of capital ultimately in Benjamin's thinking, that this is not extricable from also questions about how the production qua exploitation of these policeable, vulnerable, materialized bodies have everything to do also with their indebting. So yeah, that's hopefully goes a little bit of a way to answering your question. Just a brief side note, like the other work I've been doing on this is to link it to China, actually. He disagrees with Max Weber in Capitalism as Religion. He disagrees with Max Weber on the basis of what Max Weber says about the inability for China to produce capitalism, which obviously, as we know, is patently untrue today. But anyway, I can get into that later, like in some other context. But there's interesting ways in which Benjamin's sort of really thinking about an exit point from capitalism via its pagan character, which he also attributes to law. So what I guess I'm trying to say is like the analysis goes the other way around, but I think I don't have time to expand on that right this minute.
Okay, so we have a few more questions in the room in Berlin.
Hi, Ricardo here. I come from Luxembourg, and there, I mentioned this because there you see how Zeremonialwissenschaft, Polizeiwissenschaft merges with financial capitalism. If you have the opportunity to go there to see how castles became banks, you see you have these huge castles and they have the logotypes of banks. And my question first to Julia Nigg concerns this mixture between Polizeiwissenschaft and financial capitalism. In your recorded lecture, you mentioned Carl von Savigny, and to contextualize to whom Benjamin may be referring, when he discusses at the beginning of his piece, natural law and positive law. And now you emphasize that point about how Polizeiwissenschaft do not refer only to the police as a police officer, but to this whole German tradition of cameralism and of discussing rituals and how you must perform nobility in face of the poor. And my question is, as there are deep historical research connecting natural law to this whole literature of Zeremonialwissenschaft, to the extent that, for example, Milos Fek argues that Zeremonialwissenschaft is a derivation of natural law. Would you say that when Benjamin is playing with this distinction between natural law and positive law, his main reference is this 19th century, even 18th century struggle between, for example, Christian Thomasius on the one hand, and the Enlightenment authors? How to historicize this distinction, as usually it's interpreted as referring to Benjamin's contemporaries, Hans Kelsen on the one hand, Wetzel on the other. So how to historicize these two categories and how they relate with this point about Polizeiwissenschaft? And to Andrew Benjamin, my question concerns the point in your lecture when you highlighted that point in Benjamin's text when he discusses about the proposition that mere life would stand higher than justified life. And this whole paragraph of his text, to me, more and more reads as a discussion and a confrontation with Ludwig Klages and his whole notion of the cosmological eros and this idea that the soul should have the upper hand against spirit. And my question would be, can we read this distinction that in his fragments, in his notes, Benjamin again and again commented upon, this distinction between soul and spirit? Can we read them in this distinction that now appears in the text as mere life on the one hand and justified life on the other? These would be the two questions. Thank you.
Great. Let's take one more question from the room, if there is one. And then if you want, Julia and Andrew. Do we have any other question in the room?
No, that was it.
Okay, so let's take then one more question from the chat before you start answering the previous question. So Felipe Chamin.
Yeah, hi, how are you? I'm Felipe. I'm speaking from Bogota, Colombia. I'm a lawyer and I'm a student of philosophy. I have one question for each, and thank you very much for being here. My question for Professor Julia is about the notion she says at the end of her lecture about self-reflective life. And it's very interesting to me because my question is, how does it relate? Basically, my question is posed as, what will be the possibilities of self-reflective life to counter the power of law and the production of vulnerable bodies? And how does it appear? Because I understood you that it will be almost necessary, the presence of both. There is self-reflective life and vulnerable life. What is the relation between the two, and how does self-reflective life can resist its metamorphosis? And yeah, that is the question for Professor Julia. And the question for Professor Andrew is related to an expression I have dealt with. It appears very frequent in his work. Is the critique of law in the name of law. That's the expression. And my question is the meaning of law in that expression. That is, law as an object of critique and law as the name. What is done in the name of critique? What is the meaning of law in that sentence? And also, what does that critique entails for a life? That is, what is the transformation that is happening on a life? If you, as you have said, assume a very close relationship between law and life. That is, what I'm trying to ask you is, what does it mean to be a critique of law in the name of law, but also what transformation that entails in life? Those are Those are my two questions.
Okay.
Did I make myself clear? Did you understand the question?
Yes. Okay, thank you.
Yes.
Yep. Andrew, would you like to go ahead or?
Sure. And just in regard to the first question, it's. I mean, I almost am going to say it's too difficult to answer. It's, you know, I'm not sure about tracing these words. I think there is an engagement with Klages. I take it you said Klages, so I couldn't hear exactly, I'm sorry. And I think that there is a general attempt to take on a certain tradition within Lebensphilosophie that Benjamin is seeing. And these terms are, you know, and these terms are deployed knowing in some sense they're always overdetermined. But the actual specificity of the example you raised, I mean, to be honest, I would have to go and do some research and think about it. I'm not exactly sure whether what you say is wrong or right. I just don't know in that specific instance. I would, however, and I think I said this in my lecture, draw attention to the fact that there is the reiteration, not just there, but throughout the text, of a certain type of theological language that is worthy of comment. But that again would be a larger project. But it's his use of when he talks about the educative Gewalt, the educative violence. You know, he talks about it's only in one particular manifestation that he's interested in, and one would need to pay attention to that. In terms to Felipe's question, this is something that I wrestle with all the time. To be honest with you, I'm involved in a research project on the relationship between populism and international law with some lawyers in the UK, the States, and in Australia, and a couple of philosophers. And one of the things that we wrestle with is what status does one give to the concept of law? And once you move away from the identification of law with statute, or law taken now more broadly with something like normativity or convention, or the common law tradition in the UK, for example, once you move away from that, what is law? And I suppose that for what it's worth, I would underscore that my developing this notion of law's constancy is my way of dealing with it. And where I'm, convinced by a certain move that Derrida makes that's equally there in other people, but certainly Derrida makes it, and that's to talk about unconditional hospitality or unconditional justice, etc., etc. Now, I think that what law's constancy is the way in which one could talk about the possibility of a constancy and a continual openness to the possibility of unconditional justice. Now, for me, and this is not a claim about Derrida, it's a claim about me, for rightly or wrongly, is that what I'm after, and Derrida was never after, are criteria of judgment. So what I'm interested in is what it would mean to make a claim about either a statute, a norm, or a convention. And the ground and the condition of possibility for a law, a statute, a law, or a convention to be judgeable is that there must be that in relation to which, or something which furnishes the criteria of judgeability. So what I mean by a critique of the law in the name of the law is linked, one, to law's constancy, as I put it, but equally that the critique of law must have, in my view at least, must have some condition of possibility. And that's where the notion to me of law's constancy comes in. Now, that again, I recognize is incredibly abstract, but not now because there wouldn't be time, but I'm more than happy now to go through and talk about what that means in practical terms. And the last point I'd make is my use of the word constancy is meant to underscore the necessity for action, namely that there is the possibility of grounding action in something like, the unconditional. So when Benjamin says in that lovely little paper that's in Schollem's Tagebuch, you know, justice is the striving to make the world into the highest good. You know, I take that, you know, very, very literally in this instance.
Thank you.
So yeah, thank you for both of those questions. So in terms of, who Benjamin's referring to when he's talking about natural law, there's a number of different ways to answer this question, I feel. In the essay itself, he seems to have sort of very hastily associated it with only an idea of rational self-rule. And then a little bit later, namely sort of in the process of thinking through, thinking like through to sort of the late 1920s, when he's starting to sort of read up a little bit more on what natural law actually is, he starts sort of seeing it in the context of its backlash, it as a backlash against legal positivism. And this is, I guess, crucial in a couple of ways. I mean, first of all, you know, it just taken on its own in its reference in its brief description in the essay, in the Critique of Violence, it seems like a summary dismissal, if you will, of a certain kind of association with, as he says, like Darwinism as a sort of misappropriation of what natural is for certain ideas of what natural ends are supposed to be. But a little bit later, I think and we can also reread the essay in the context of this later sort of recognition, is that the restriction that he places on himself in the Critique of Violence are to a kind of synonymity between rule of law and the availability of a constitution. So there's no sense yet in which natural law can be understood outside of a modern European context, specifically. And why this is interesting and important is that when you're, you know, one wonders like what he's referring to with natural law, and one maybe takes into account that he sort of tries to educate himself on it after he writes his essay, lends a nuance to precisely one very important thing that he actually does say in the essay, which is what he says about self-defense. Self-defense doesn't sit on the same chronology as the evolution of constitutional law. In fact, you can see in the stuff that he writes in the 20s, specifically when he's how he describes Socrates' death in the Tagesspiel book, and that, you know, read that as like illustrate like his idea on like what on a transitional state, basically on legal transitions, essentially, with respect to life. Right, and with respect to life's relationship to law, you sort of start seeing natural law as a very important means for throwing a historical lens onto what becomes mythified as a form of violence, but that was in fact a form of self-defense. So Socrates, in as much as he becomes a figure, for instance, of the inauguration of modern law, and specifically law that sort of is tied to a Christological understanding of fate, depends on the criminalization of self-defense. In a nutshell, that, I mean, it's a very truncated way to put this, but natural law acquires a very different sense in the context of like his sort of thinking again through the lens of through the lens of a philosophy of history, as he exhorts us to do at the end of the essay, and see it in a dynamic that is sort of not synchronous with one another, right? That actually sort of allows us to specify completely different temporalities on which law inhabits space, and yet asynchronously together in certain parts of the world. So still later then, I think when he's thinking about natural law, I think he's thinking specifically in the context of like a backlash, as I said, against the institution of legal positivism, and bringing it also then back to a broader context that he gleans from the history of law, or like historical studies of law. So this is where Jähring becomes interesting for him. And, you know, it's not like, you know, these are like three completely sort of discrete traditions for him. In the sense, I think he's interested in this idea that, for instance, Jähring in particular is important for him in articulating, which is, you know, there is something inherent, you know, that law contains something inherent for which any rational person must strive in a particular way. And that is contained in at least one idea of law. And that idea of law doesn't have to be synchronous with modern European constitutional law. That is also constructed on the criminalization of a certain kind of legal relationship to life, right? He gets some of these ideas then, right, which are, you know, which complicate what he says about natural law in the essay, from historical studies of law, also in sort of non-European situations. And one person in particular becomes really important for him, and that's a himself very dubious figure, Walter Lehmann, who was important for sort of, I mean, amongst other things, he was one of the people who sort of inaugurated what is now the Ibero-American Institute in Berlin. So he brought back a whole bunch of artifacts from Mesoamerica, anyway, like, long story short, Benjamin had a interest in sort of linking together his thinking about natural law ultimately in context of a historical understanding of where certain criminalizations of certain like historical forms of law occur, and where therefore an opening might be seen with respect to inherently like an inherent aim contained within law that, according to certain natural law principles, ought to be accessible to any sort of reasonable person. This, I think, brings me to the second question a little bit, right? So the question of like this idea of the self-reflexive life. So the particular sentence I was referring to obviously is, and the word actually, in the German, it's that he's actually truncated a lot of thought into it. So there's just one word that Benjamin uses. That's he's referring to die Besonnenen. And that can mean a whole bunch of things, but in interest of, you know, making this entire sentence comprehensible, this is obviously like directly in the passage about the police ranging around in vulnerable areas, but this particular sentence talks about how the police, in a nutshell, like the police ranges in these vulnerable areas, or areas in, that are deemed in need of policing because they're somehow vulnerable. But at the same, you know, but it's because it's so anxious about it's because the state is so anxious about not having a defense against certain kinds of people, and the certain kinds of people, that's what he's referring to by by die Besonnenen. There's I mean, you know, the word is kind of like anybody or everyone or anyone, like he doesn't specify which, right, that has an inkling of what's going on. And I think to sort of more generalize this discussion a little bit more, I mean, independently of like what Benjamin leaves unsaid, I think what's interesting here and important here is that anyone has that inkling, right? Anyone has that capacity for self-reflection. It's not the intellectuals, right? It's not a certain political elite, for example, right? It's not a indictment of the police from the position of elitist politics. It's anyone, right? It's anyone that ought to have, anyone, regardless of where reflection is supposed to be situated, has that inkling for self-reflection. So anyone ought to be able to see exactly those areas in which the state fears its demise so much that it sort of ranges into these vulnerable areas. So it's not really a question of how that goes together with vulnerable life. It's more like all vulnerable life has that capacity to begin with for Benjamin, I think, at least at least in the way this entire paragraph works. And I think in the context of his broader understanding of maybe natural law, even if it's sort of slightly unworked out really in the essay itself. It's to, he's rigorous about limiting his reflections to modern Europe in the essay, and therefore indicating that he's very much aware of the limitations placed upon the idea of self-reflection and on vulnerability and on law, legal power, legal violence by the modern European legal tradition. And so I think, I think that's a really important context to sort of consider in respect to what he does and does not say about natural law.
Okay, thank you. So we are on time, but since we started a little bit later, if you all agree, we can take the last two questions. Yeah. Okay. So we have a question by Shailan and then Winnet.
Thank you, Alexis. And I'm Ceylan Begüm Yıldız. I'm a PhD candidate at Birkbeck School of Law. And first of all, thank you for this fascinating lectures, especially the part about vulnerability in Niobe. For me, it helped me. I've been wrestling with that myth for a while, with that part for a while. It really cleared opened some perspectives for me. I was wondering, Julia, whether you can unpack or expand further your third thesis. If I'm not remembering wrongly, that in which you're suggesting that in Benjamin's reading of law, law transforms into the non-law and back to law. So I kind of sense a dialectical move here, and I was wondering whether you can clarify that. And I have another question for Andrew as well, if I may. I also wrestled with, for a while, and Cassirer and German Romantics and Benjamin. My work is on the myth of the state, its violence, and its legal unaccountability. So thank you so much for your perspective. I was, however, wondering about the possibility and performance of divine violence that awaits as a potential to overcome myth and mythical violence. The moment that made me think is your comment that you kind of said that it is not necessarily a pleasant thing because it can, in a more practical terms, it kind of gestures towards self-sacrificial actions, or brings more death at the end. So I was wondering, we are maybe thinking about a more philosophy more towards life and so on. What is this possibility and performance of divine violence, and in kind of more practical terms? Thank you.
Winnet?
Yeah, thank you so much. I'm a cellist and a musicologist, and I'm calling in from Abu Dhabi. here in the United Arab Emirates. So, and thank you so much to all of you who are hosting this. And this question is to you, Andrew. You brought back into your lecture the question of aesthetics and art, which of course is really important to me because I came to Benjamin, this conversation, the critique of violence is newer to me, but more through the Trauerspiele and thinking about the performance of death on the stage. And I worked at LA Opera, so was part of actually thinking about what this looks like on the stage and how we can imagine it. So from these very practical aspects to a kind of theorization of the performance of death. And maybe just one thing, you know, when you, Andrew, were saying that, you know, Benjamin is a philosopher of life, or that's how at least how I heard you say it. I'm wondering also if he is a philosopher of death, because it is the measure of death and the conditions of death. I'm thinking about the end of the artwork in the age of mechanical reproduction. And this also goes back to what you mentioned, Julia, maybe this idea of production of bodies, where he talks about the bodies pouring into the trenches during the First World War, that it's actually the conditions of death then that become the measure of life, of a good life. And also I'm thinking about Heidegger and being in time and the idea of, you know, the death is the fruit of the good life, but what happens if the conditions of death are not good? So that's one aspect, but I want to go back to, so that's part of the question, but the other part is about art and aesthetics and the critique of myth. And I want to ask, how is the way, I'm thinking back to Kassir and the conversation about Plato, the deep anxieties about poetry, the censorship. He's seeing poetry both as an individual, but also as a statesperson. There's this duality of his engagement with the arts, also with music, deeply anxious about music and particularly the Ionian, the Turkic modes. So how does art, whether in Kassir or in Benjamin, become both critique of myth, but also standing outside, in a sense, the sort of hegemony of myth, but at the same time reinscribing it? And I'm really interested maybe in the Trauerspiele particularly, because what he says is the tragedy, you know, the hero is about this transcendental design that breaks through, and that the Trauerspiele are about immanence and the subject of history. They are subjected to the contingencies of history. And I'm interested in that question, if it's making sense. So that's for you. For you, Andrew.
Andrew, you are mute.
I know, I made the mistake. Look, it's so difficult to answer a question like both questions in to do them justice, to be honest with you. I mean, the passage in regard to Ceylan's question, the passage, I mean, the moment, the comment I made was that let me find another way of doing this. Let's take something absurd like the plastic bag. Okay. In Australia and in most countries now, the plastic bag is being banned. People don't want to use them. It's been outlawed in shops. And everyone thinks this is trivial. On one level it is. On another level, the largest land mass in the world at the moment, the new land mass, is the Great Pacific Garbage Patch, which is a patch of plastic that is larger than Greenland, and it floats in the Pacific Ocean. It's a problem in legal terms because no one can be attributed responsibility or can take responsibility. So the problem for law and international law posed by the Great Pacific Garbage Patch is just extraordinary. Now, one of the things that becomes interesting is that if you say that while it's true that one should talk about the logic of capital, and we should equally talk about the logic of carbon. If you think about the development of any notion of urbanism, is presupposed it presupposes a relationship to the logic of carbon and therefore the petroleum industry. Therefore, what the difficulties that we have, and this is where divine violence comes in, is that if one doesn't take it in an apocalyptic sense, but sees it as strategic and pragmatic, but linked to, on the one hand, what I've called law's constancy, but on the other, the suspension of the organizing logics that control us, i.e. capital and carbon, it becomes then possible to rewrite the arguments about the petrochemical industry, the arguments about plastics, in precisely these sorts of terms, and then to begin to frame our understanding of it in terms of a version of the future that's linked to the idea of a suspension. And this is something where, and again, I can't do it, and the time doesn't allow, but if you take Benjamin's notion of the destructive character as absolutely bound up with the question of divine violence, just as a work in progress, and then say, what does the destructive character do? The destructive character, and I paraphrase Benjamin here, I forget the German, it's something like, hat kein Bild vor ihm, has no image before him. So the destructive character he's not a utopian, God forbid, doesn't create a world based on an image, but creates an opening in which it's possible to think and act in another way. In other words, destruction as an instance of divine violence is linked to an opening. And the final point about that, I think if you look at in the Arcades project, I think there are two uses. There's certainly one use of the word caesura, and you can take that right back to his interest in Hölderlin's commentary on his own Sophocles translations, where the word caesura again occurs. This counter-rhythmic rupture. Now, in English, if we use the word allow, what we mean is this. If I say, I allow my children to go out and play, it means that I occasion the possibility. What will happen, I can't predict. I hope they're safe, I don't know. I'm simply allowing. So there's something there in Benjamin linked to what I call, and my commentaries on it, a caesura of allowing. And I link that to the destructive character. I link that to divine violence, is that what's going on, if you like, is the suspension of organizing logics by reading them as organizing logics, and capitalism is one. Capitalism is the one in every day you can go shopping and every day is a feast day. The suspension of that yields openings. And those openings can be like the weak messianism, as it were. It's these moments that are strategic, but at least one can talk about them. But they need to be understood as linked to suspensions. But that's just a series of broad brushstrokes. Gwyneth, in relation to your question, again, it's a very difficult. There's Benjamin's own writings on art, okay, which are interesting or not depending on one's point of view. Everyone talks about the work of art paper, and it's interesting to a certain extent, and it is. So there's Benjamin's actual writings on art, which are interesting and important. And then there's the sort of thing that I suppose I'm interested in, is how could you think about art in a Benjaminian way? Now that's sort of my shtick, I suppose. I'm interested, in that. Now, in regard to the question of music, it's something I love, but I know nothing about, so I can't really comment. In terms of the production of death, it's clear that the line in through Benjamin that deals with death has to be run to be brutal. If Heidegger is dominated by the Sein zum Tode, the being towards death, what Benjamin is interested in, to be polemical, is neither death nor life, but the interplay of life and justice. And that therefore in a very old-fashioned sense, you could say he's interested in the good life. Now, it's also true that that necessitates a systematic engagement with death, melancholia, a whole series of moments. But there needs to be a much more extended argument to show in what way those moments can be incorporated within a larger project. But again, the difficulty is, I forget, he dies at the age, 48? He lives in hotels making money, writing articles and translations. It's very difficult. He wasn't in a university. It's very difficult to find and insist upon an absolutely always consistent project. It's there on one level, but it ranges backwards and forwards. Certain texts are strategic, certain texts are pragmatic, certain texts were never meant to be published, others are. And what we do is we range across this I have some on my desk, the complete works, finding things. But the idea that there's this kind of always consistent project is, I think, illusory, though people like me insist that there is one and try and recover one from it. But it involves levels of abstraction and certain forms, to be honest, of interpretive violence, but that's almost inescapable. Julia. Sorry.
Yeah, so thank you for the question. Actually, it allows me to sort of emphasize one point, which is that when Benjamin uses the word Rechtsgewalt, it's specifically not Obrigkeitsgewalt. And I think this is crucial to the disentanglement of Benjamin's essay from any sort of Schmittian overtures, right? Especially with the translation of the final sentence of the essay, where the question of what the Waltende Gewalt is supposed to be, I mean, existing translations have it as like sovereign violence, is completely misleading because Benjamin has no interest whatsoever in sovereignty per se. He uses Rechtsgewalt as opposed to the other available term, which is Obrigkeitsgewalt. I won't get into my particular translation choices of using pending, but I do just want to briefly point out that it cannot be seen in isolation from the idiom from which Walten is decomposed, which is Schalten und Walten. So anybody who actually knows any German will recognize this idiom straight away. Schalten und Walten is an idiom. Schalten appears in the third to last sentence in the essay, so Benjamin clearly is playing with this idiom. Schaltende Gewalt is mythic violence. There's another kind of violence, there's verwaltete violence, which I think the previous translation had administrative violence, which is crazy because, he's not talking about paper clips, or withholding paper clips. He's talking about expended violence, a past participle of walten, right? And therefore divine violence is waltende violence. It's not per se anything prevailing. It's definitely not attending, because attending would be much more apropos to the Schalten, the mythic violence. This is specifically a withholding violence, a kind of sort of divine violence that breaks apart the expenditure of violence that in the process of its expenditure perpetuates mythic violence or law-related violence, and ironically also contains within it, therefore, the kernel of its dissipation. The only sort of withholding, right, the only way that, you break away from a dialectic, and I'm going to get to the question very soon, the way you break out of the dialectical, dialectical self-perpetuation of law-related violence is by not expending violence. Now, whatever else that's supposed to mean, this is clearly what he does in the last few sentences of the essay. So coming back to your question about thesis number 3, or my thesis number 3, law, under quotation marks, I think, right, viewed from the philosophy of its history, is the continuous transformation into non-law and back into law. The point, I think, here is that, especially, when he's concerned not with an extra legal kind of sort of decisionism, that's sort of like extra temporal, right, that kind of comes in to preserve law by ending the entire institution of law via a sort of recognizable situation of some sort, like that, that was sort of rough, pretty bad, rough characterization of like sovereign decisionism. His insistence that Rechtsgewalt be the sole vehicle for his analysis insists therefore also that historical recognition alone is the sole criterion for distinguishing between what is and is not law, in the sense of what it legitimizes. So Rechtsgewalt specifically, rather than sovereign power, right? Rechtsgewalt is seen by him as a formative principle in this way of looking at law from the perspective of this philosophy of history. What this means, right, is that the state then becomes describable as claiming or having a claim on a monopoly on violence only in as much as it is threatened by everything around it that threatens to posit new law. So law, seen strictly from within the sphere of law, Rechtsgewalt, the force of law alone, right? Not anything extra legal, not the judiciary, not the executive, but the, not just law itself, is therefore ambivalent on its own terms, right? What this means is that, law is ambivalent in a particularly time-related sense. Law or legal violence means legalized forms of violence that deploy to preserve a monopoly on the use of violence, does so by delegitimizing anything that it deems to be used for natural ends, but sanctioning anything else that is supposed to have some identifiable law-positing character in it, that is to say, when it serves normative ends. And in this case, from this perspective, this is not a dialectical situation at all. Historical recognition grants law the legitimacy it wants by marking its historicity, and therefore where law has to recognize its own end in order for it to be recognized as law, as legitimate, right? So in a nutshell, it's the same thing as, like, as gets played out in the final 3 sentences of the essay. The means that legal power has at its disposal are the very means of its own undoing. And so I had in my mind much more of a topological figure, but that's because I work on math in my other life. But like in this, this is like a figure where legal power sort of turns into its own outside, and back into its inside, but like in the interim, like completely transform its character, because historical recognition is the sole criterion by which, law posits its own legitimacy. And where this becomes then tied to other sort of forms of violence, like specifically like where he's talking about capital elsewhere, right, is where this idea of a trans-historical principle is tied to it. So a trans-historical principle of causality is tied to law and therefore ties it to a dialectic, right? That's when sort of it becomes tied to then other forms of violence. So, the word he has for this is fate, right? So, yeah. And this then becomes tied to, obviously, like binds law to legitimacy in matters over life and death as well. But it's when it becomes dialectical, it becomes tied to a sort of overarching principle of causality, a trans-historical principle of causality, that legal violence becomes bound to other forms of fateful violence.
Okay, well, thank you everybody for joining us today for the first public session of Working with Benjamin on Law. Please remember that we have a second public session on Saturday at 6:30 Berlin time. Let me thank to our keynote speakers, Julia and Andrew, for being here with us and for your fantastic lectures. Thank you, Andrew. You know that Andrew is in Melbourne right now, so it's a bit late over there. So thank you very much for being here with us. So in terms of this next session, our workshop session with the participants, can we resume at 5? Is that okay? Okay. Well, let's start the second session then, the workshop session at 5. And again, thank you everybody for being here with us for this public session.